Next picture of where we are this semester. First week was introductory materials, including information that in order to have a good judgment, one that you can actually collect, you have to have three things. You have to have subject matter jurisdiction, you have to have personal jurisdiction, and then you have to acquire that judgment in a manner which is consistent with due process. 2 weeks ago we talked about subject matter jurisdiction for federal courts. We said that's going to be our test for apples. For federal court, I want you to remember and keep these separate. The federal court test is whether or not it's a federal question or diversity. And federal question, we know, arises under the U.S. Constitution, the federal laws, or a federal treaty. That's a federal question. Diversity is probably a state law claim, which is between citizens of different states, and it exceeds $75,000. That's subject matter jurisdiction for the federal courts. Last week we talked about subject matter jurisdiction for the state courts. If it's a federal question, in other words, if it arises under the U.S. Constitution, federal laws, or federal treaties of the United States, it has to be filed in circuit court, because that is the court of general jurisdiction. That's where the concurrent jurisdiction overlaps. And then if it's not a federal question, which again is going to be state law claims, then you've got to look at the dollar amount of your claim to see which court it goes to. Over $20,000, it is exclusive original jurisdiction to the circuit court. Not exceeding $6,000, it is exclusive jurisdiction in the district court. And then between $6,000 and $20,000, you get a choice, because they have concurrent jurisdiction, which means either court can hear it, and then you have to take factors into consideration, like whether or not your client wants a jury trial, the speed at which the case is supposed to be resolved, not necessarily how fast it's actually going to be resolved, but how quickly it's supposed to be resolved, and then other things like discovery, which we'll talk about next semester. So that takes care of subject matter jurisdiction for state and federal courts. This week we start getting into personal jurisdiction. And this week and next week are both going to be personal jurisdiction. This week the lecture is entitled, How to Get Them Into Court. Next week the lecture is, well, the cases, not much of a lecture because we're going to be doing the case law, is how to keep them in court. So this week is how to get them into court, next week is how to keep them in court. Now, how many of y'all are at least about 2/3 done with your reading assignment for your cases? Y'all are about right on track. Get the other third done this week, plus summarize the material we covered today. There is a writing assignment to turn in next week, and it's today's materials only, not your case law. Your case law gets turned in the week after that, after we summarize it. And we are going to summarize it in class. Believe it or not, it comes down to something real simple I can write on one whiteboard. 150 years worth of Supreme Court case law, and we can boil it down to a summary which fits on one board. So finish reading your material so you can get the big picture next week as we cover. So this week, how to get them into court. Remember, the United States, when it was created, adopted the common law of England. Y'all remember that? How did the courts in England get somebody before the court? Do y'all know the answer to that?
They sent somebody out to drag them in.
They sent somebody out to drag them in. Literally, they go like this. They go like this, sneak around. They put their hand on their shoulder and say, "Come with me." Now, the visual on that, actually walking up to somebody and putting your hand on their shoulder and saying, "Come with me," has been adopted by the actual U.S. Supreme Court as part of their rationale for being able to keep somebody into court. Because it's real easy to go out and get somebody that lives in your county and put your hand on their shoulder and bring them to court, because they live in your county. But it's different when you go outside of your boundaries to try to bring somebody into court. And for that purpose, you have to have something called a long arm statute. And it's the arm that reaches out and puts their hand on your shoulder and brings you into court, which is the long arm statute, if you happen to be outside that territory. Now, how many of you so far have read something about long arm in your reading assignments? Does that visual help you understand kind of what the long arm statute is? It's giving the court the authority over that person. But it's somebody that's outside of their boundaries usually. We're going to get into part of that this week, but technically we're getting into how to get them into court. Now, sending the person out to actually go lay their hand on the shoulder of an individual and say, "Come with me." What do you think the person in charge of the court has to do to have that person sent out and actually come back with an individual?
Give them some type of authority from
They have to issue an order called a summons. You have been summoned to come to court. And a summons is simply that. It's a court order that says you are required to come to court and to answer against these charges. A summons is nothing more than that. In fact, generically, there's a term you need to be familiar with, and it's called process. Process is actually two different things. It is a noun and a verb. Process as a noun is a piece of paper which represents the court's order directing somebody to go out and get this person and to bring them before the court. That's a summons. Well, the order to go out and bring them to court is process. There are several different forms of process. If you look at 4.1 in your federal rules, 4.1a says process other than a summons under Rule 4 or a subpoena under Rule 45 must be served by a U.S. Marshal or Deputy Marshal or by a person specially appointed for that purpose. So, inherently in that one statement, there tells you that there's at least three different kinds of process. One of them is a summons, and that's the one we're concerned with right now. The other one that they mentioned is a subpoena. Subpoena we're going to get into greater detail next semester, but here's the difference between a summons and subpoena. A summons is, you are hereby ordered to appear and defend this cause. Whatever the claim is against you, you're ordered to appear and defend. A subpoena, however, is you are hereby ordered to appear and testify. So the difference between those processes is, yeah, you have to appear to do something, but one of them is defend a claim that's been brought against you, and the other one's just to appear to testify on somebody's behalf. So you get the idea of process as an order directing somebody to appear and do something. One species that we have today that we're going to cover today is a summons, which is appear and defend against this action. And the other is, next semester, appear and testify. Y'all got that? Yeah. Process is the generic term for an order to appear and do something. Specifically, a summons is to appear and defend against this action. So that takes care of Rule 4.1 as far as it requires us to actually have somebody go out and deliver that written order, which is called a summons, to an individual. Now, look at Rule 4 in your federal rule book. Rule 4A tells us exactly what a summons has to look like. Now, I've got the state form on the overhead as an example, but the state requires the same thing as the federal does. Let's go through the requirements. Number one, it has to have the name of the court and the parties. Well, you can see by the caption up across the top, it says, in the blank court of blank county, Alabama. Well, the federal form just says, in the United States District Court for whatever district of the United States. That's the key difference between the Alabama form and the federal form. And then it's got to have the name of the parties. You see this blank over here on the left that says names of plaintiffs, and the one on the right that says names of defendants. That's pursuant to the requirement of Rule 4A that says you have to have the name, not only the names of the courts, but the names of the parties. It has to be directed to the defendant. This is what a summons is. It's a court order to a defendant. So notice here it says notice to, and it says name and address of defendant. In other words, it is directed to the defendant, right? Now, one question came up Thursday. What if you have more than one defendant? You have more than one summons. You have one to one defendant. You have another one to another defendant. Real simple, because you have to have a court order directing each person to appear and defend against the cause. State the name, address of the plaintiff's attorney, or if unrepresented, the plaintiff. Well, down here at the bottom, it says the plaintiff's name of attorneys and their addresses are. It has to state the time within which the defendant must appear and defend. That's what makes it a summons. Notify the defendant that failure to appear and defend will result in a default judgment against the defendant for the relief demanded in the complaint. Then it has to be signed by the clerk of court, and then it has to bear the court's seal. That's technically a difference between federal and state court. State court doesn't require the seal, federal court does. For purposes of your exam and for the bar, you need to know that it needs to contain the court seal. So let's see what it says directed to the complaint, to the defendant. The complaint or other document which is attached to the summons is important, and you must make immediate action to protect your rights. You or your attorney are required to file the original of your written answer, either admitting or denying each allegation in the complaint or other document, with the clerk of this court. A copy of your answer must be mailed or hand-delivered by you or your attorney to the plaintiff or attorneys of the plaintiff, and then you list your name as the plaintiff or your attorney's name, and then you list your address or your attorney's address if you're represented by an attorney. Going a little further down, it says this answer must be mailed or delivered within blank days after this summons and complaint or other document were served on you, or a judgment by default may be rendered against you for the money or other things demanded in the complaint or other document. So there's your warning. You have to tell them the number of days, and you have to warn them that a default judgment for exactly what's asked for in the complaint will be rendered against them. Now, why do you think that it has to be exactly what you've asked for, and nothing more and nothing less?
So that they know. I mean, they don't say, well, I didn't know about this. Blah, blah, blah. Well, they agree to the judgment.
So that they don't know, but what are the legal terms for that?
So that they're informed.
But they're served.
You get closer by saying notice.
Due process.
How about due process? Notice and an opportunity to be heard. Well, the summons accomplishes both of those things. You give them notice of the pendency of the lawsuit, but it's also in their defense that they have noticed that this is the only amount of money that they're going to get awarded against them and nothing more. What if the plaintiff decides that they want to sue for a breach of contract and they only ask for $10, but they forget consequential damages for another $1,000? Their complaint says, I want $10 for breach of contract.
That's all they'll get.
You represent the defendant. What do you tell the defendant to do?
Don't shoot them.
Let them take the judgment.
Yeah, right.
Because at that point, they can't come back and get the $1,000 for consequential damages. Remember that you get 1 day in court? Transsubstantivism? No, it's the other one. Transactionalism. Thank you. The transactionalism arising from the same transaction or occurrence. If they only ask for $10 and not $1,010, let them take the judgment for $10, because they can't come back later and ask for the extra $1,000. So it gives not only notice to the defendant, but it it protects the defendant that this is all the plaintiff wants. That's exactly all they get. Because to vary from that, to give them more than what they've asked for in the complaint, would violate due process because it doesn't give notice that they're going to be getting anything more. You see how it works both as a sword and a shield. So that's an important part. Now, the next section down, to any sheriff or any person authorized by the Alabama Rules of Civil Procedure for process, you are hereby commanded to serve this summons and a copy of the complaint in this action upon the above named defendant. And then there's some other options in here about certified mail. So, what did I tell you a summons is? It's a court order, right? A court order that the court sends out directing law enforcement or somebody else specially appointed to go out and serve this on a defendant for them to answer and defend. They have to appear, answer, and defend. But it's their choice if they don't want to defend. But all they're going to get is exactly what's in the complaint because it's default. Any questions about that? Remember, this is just the first part about how to get them into court. How to get them into court. The first thing you got to do is get a summons in their hand, and the summons has to be accompanied with a copy of the complaint to give them notice of exactly what it is that they're required to answer and defend. Now, let me ask you a hypothetical question. This is called process, right? Piece of paper, the summons is called process. What if, instead of using one of these court forms, I just write a letter to the defendant that says, please find enclosed a copy of the complaint. If you don't answer it, I'm going to take the judgment against you. See you later. Goodbye.
You didn't do all the requirements of 4A.
You didn't do all the requirements of 4A, so what do you call that?
A notice? No wait.
A
warning, junk mail.
All right, what do you, hold on, what do you call that piece of paper?
Crap.
A legal term instead of crap. There's a special term you need to know about this, that if there is a defect in the paperwork itself, it's called insufficient process. And technically it's an insufficient summons, right? Because the summons is part of process, it's one of the forms of it, but generically it's insufficient process, and it's substantively defective because it does not include everything that's required to be included under Rule 4A. So there's a substantive component to it, and then there's a procedural component to it. But right now, it's real easy to say if it doesn't have all the requirements of Rule 4A, the notice, directed to the defendant, court order to somebody to deliver it, a warning as to default judgment, how many days they have to answer. Oh, you want to know how many days to answer?
14 days in district, 30 in circuit.
Wow.
14 days in district, 30 in circuit.
Okay, so in the United States District Court, I have 14 days.
Oh, I thought you were state.
No, all the courts. All the courts.
Yeah, I was speaking about state.
Okay, he's right for state.
Yeah.
14 in district, unless it's an eviction or an unlawful detainer, and then it's only 7.
Correct.
30 days in circuit, but if you're in the federal courts, which you'll be tested on, it's federal, you have 28 days. Federal courts, 28 days. And you need to know those days because you've got to fill in this blank here that says the warning, how many days you've got. Everybody with me? Yes.
That doesn't include weekends and holidays, correct?
In federal, it counts weekends and holidays.
State court.
State court, it's only if it's less than 11, does it not? Yeah, you're right. You got to look at counting days. But since all the days, 14, 30, and 28, are all more than 11, we don't have to worry about the difference in counting between federal and state. So it's 28 days in federal, which is what you'll be tested on. But in state court, what you're actually going to practice, it's 14 in district, 30 in circuit. But if it's an unlawful detainer, which you know is for possession of property, which is in district court, you have 7 days. Y'all got that? 7 days to get possession of property. All right, next section. By the way, did y'all get that? If there's a defect in it, it's called insufficient process. That is a key buzz term that you need to know. Because on the bar exam, if you see something that comes out where it doesn't meet the requirements of Rule 4A, you need to call that insufficient process in order for the bar examiner to know you know what you're talking about. So use that term and use it correctly when there's insufficient process because it does not meet the statutory or the rule requirements of what should be included in a summons. Next one, B. This is Rule 4B. On or after the filing of the complaint, the plaintiff may present a summons to the clerk for signature and seal. Well, that's because you have to have the signature of the clerk and the seal of the court in order for it to be a valid summons. If the summons is properly completed, the clerk must sign, seal, and issue it to the plaintiff for service on a defendant. The summons or a copy of the summons that is addressed to multiple defendants must be issued for each defendant to be served. So you have to have one for each. Now, technically, I guess, if I complete this form and I list out each of the defendants on here, instead of one form for each one, I'll scroll back up on the form where you can see what I'm talking about. Notice to this defendant at their address. I could put multiple names in there, like Mr. and Mrs. John Smith and their address. But guess what? I got to give one to Mr. Smith and I got to give one to Mrs. Smith. Because each defendant must have one. Now, if I have 3 people listed, like Mr. Smith, Mrs. Smith, and baby Doe Smith, and they all happen to be at the same address, I've got to get 3 summonses out because there's 3 defendants. So it's one for each defendant. Yes, ma'am.
So if it's a juvenile and they have like a guardian, does it go to the residence of the juvenile or does it go to the guardian's residence?
We are actually going to get to that in a few minutes.
Oh, okay.
Because remember, we're on how to get them into court, and that's going to be how to get a juvenile into court. The whole lecture today is how to get them into court. So that's the substantive provisions. What about Rule 4B? What if the attorney forgets to take it by the clerk's office and get them to sign it, put a seal on it, but they just throw the blank summons together with the complaint in an envelope and send it over to the defendant?
Insufficient process.
Insufficient process. Y'all got that? That's good. That is the term because it's defective. The paperwork is defective for not meeting the rule requirements. Now, service. That's the paperwork that has to be delivered. The service part of it is broken down into 2 parts. First of all, who can deliver it, which is the procedure of process. And then you have the delivery itself, which is called service of process. So you know that process here is who's delivering it, because it has to comply with the rules. By the way, Rule 1 has no application in summonses. What that means is that you have to strictly comply with the requirements of the rule in order to get somebody into court. Alabama Supreme Court long ago issued an opinion that says you have to strictly comply with getting somebody into court. Why do you think that is?
So that you just don't bring everybody off the street into court?
Well, it actually is because it's so closely tied with notice and an opportunity to be heard. If you strictly comply with the notice requirements, then due process has been satisfied. If you're a little slack on the notice requirements and you don't follow them strictly, you can't really say that notice has been satisfied. So the courts actually require you to strictly comply with process and service of process in order to have somebody on the hook for the case.
You said procedure and process.
Process and service of process. There's procedural process. We've covered substantive now. There's a defect. Procedural is who delivers it. And service of process is the actual delivery of that document, how it is accomplished. All right, now in federal court there is one big exception, and it's probably the one you need to cover first, and that's called waiving service. And it's under Rule 4D. 4D says an individual, corporation, or association that is subject to service under 4E or F or H has a duty to avoid unnecessary expenses of serving the summons. The plaintiff may notify such defendant that an action has been commenced and request that the defendant waive service of the summons. Now, the notice and request must be in writing and be addressed to the individual defendant, or for the defendant subject to service under 4H to an officer, managing, or general agent, or any other agent authorized, the name of the court where the complaint's filed. By the way, if this is a lot for y'all to get, there's a form in the back of your rule, on the back of Rule 4. If you turn over to page 5, that's the form for the notice. It's a form for the waiver of the service. Now, it requires that you actually cooperate in the service of documents. It says they have a duty to avoid unnecessary expenses. Look at number D2, your failure to waive if a defendant located within the United States fails without good cause to sign and return a waiver requested by the plaintiff located in the United States. The court must impose on the defendant the expenses later incurred in making service and the reasonable expenses, including attorney fees, for any motion required to collect those expenses. Everybody with me? Every defendant, this is your notice, the only notice you get, you've got a duty to not cause unnecessary expenses for a service process. For actually getting that process into your hand, you can waive it. The good part is waiving service doesn't waive subject matter jurisdiction, and it doesn't waive personal jurisdiction. The rule also says it doesn't waive venue, which we'll cover in 2 weeks. Venue is just the right courthouse. Instead of Tuscaloosa, it's going to be Birmingham. So you're in the proper court, but not the proper courthouse. You don't object, or you don't waive any argument you have as to venue by simply accepting service. You just waive the expenses caused by getting that summons and complaint delivered to you. Yes, ma'am?
So the defendant has the responsibility.
A duty.
Or duty to not run up a cost. But
Yes.
in the real world, they evade that. Like we
This is only federal court.
Okay. I was wondering because I was like.
This is only federal, and I'll preface that by saying waiving service is only in federal court. It's not in state. In state court, they do evade the crap out of service.
Right.
But in federal court, if you do that, then you're going to be sent a bill for the process server that had to track you down, and you have to pay it. And if the attorney's got to file a motion to get their expenses back, then you've got to pay their attorney fees too.
But even in state court, we can ask for the cost about in the judgment.
You can ask for them, and there's case law on how much you get. All right, everybody got that? Federal court defendant. Yes, Mr. Francis.
You're avoiding serving somebody, which is a kind of the hassle. So I'm sure there's a lot of dispute about that. I still don't understand waiver. Of course, that could be misused. So how do you get around that service? I'm still not clear.
Well, look at it this way. It's simply me getting the paperwork into your hand, and then what you do with the paper after you get it is up to you. You can object to everything in there, because accepting the paper itself is not waiving anything. But you're just waiving me having to pay somebody to track you down and serve you.
So do I sign for it? You're giving me paper, I sign?
Yeah, there's the letter that's in here, the form that's in the back of Rule 4, it's a waiver of service form. You give all the information required to be in that waiver. There's a place down at the bottom for the defendant to sign and send it back to the plaintiff's attorney, waiving service. Everybody got that? This is something unique to federal court here is that you can waive service. And you actually have the duty to do that. So what happens if a defendant doesn't waive service?
They don't have a good cause, they pay.
They don't have a good cause, they pay, right? So if I have to hire a process server that tries to serve them 12 times because they're avoiding service and run up a $1,000 bill trying to get them served, and 12 times, that's about $85 a time, right? For $1,000? That's pretty reasonable for a process server. Then after they get them finally caught, I send them the bill for them to pay and give them 10 days to get the money back to me, and if they don't, I file a motion with the court not only for that $1,000 but for another couple hundred, $2,500 for me to file that motion and to go to court and have a hearing as to why they unreasonably did not accept the summons and complaint, or did not waive service, which is accepting the complaint and the waiver of service form. Everybody with me? Look at Rule 4M real quick. 4M says that as a plaintiff, you have to get your summons and complaint served on a defendant within 90 days.
So is that I was going to ask.
In state court, it's 120. In federal court, it's now 90, and they changed that like 2 or 3 years ago.
So does that, I'm just trying to think about at what point would you decide to do this waiver of service? So I know you got 90 days, so after what, 3 tries, 4 tries?
Well, let's talk about that. Practice pointers. If you're filing a lawsuit in federal court, remember first you have a bouncer at the front door because there is a presumption against the federal court having jurisdiction. That's why you have to give them a jurisdictional statement that says this court has jurisdiction and has to hear this case pursuant to this code section. Then you've got this other bouncer that says, hey, if you don't get your papers served within 90 days, I'm dismissing the case. Look at Rule 4M real close. It says the court must dismiss the case. So that's bouncer number 2, right? You go find out there's bouncer number 3. We'll talk about him in 2 more weeks. That's called venue. You file it in the wrong venue, it says the court shall dismiss your complaint. That's the first directive. So you got all sorts of bouncers at the front door of the federal courthouse trying to keep you out. Do you think? Sometimes you cannot because, yeah, statute of limitations for one, and then sometimes it operates as prejudicial to your client. So I'm telling you about this about federal court for you to know if you want to go to federal court, you can, but you better be on top of your game. You got to have all your ducks in a row up front. 90 days to get them served. So you asked about the waiver of service. Well, since everybody has a duty to waive service, what you do is when you file that complaint, you've got a stamped-in complaint, then you send this waiver of service letter that's got all the required information in it. It says here's the court, the case number, the parties, the claims. By attaching a copy of the complaint, you've done it all. And said, please waive service on this. And if you do it at the very start of your 90 days before your case is dismissed, how long do you give them before you start to panic that they're not going to accept service and that now you've got to go out and try to get them served?
60 days.
Okay, let's go with 60 days to start with. I see Ms. Coughlin shaking her head. No, don't go 60 days. And Ms. Willis is saying no, not 60 days. At the end of 60 days, you don't have the complaint or the waiver of service back. What are you going to have to do? Well, remember, you don't have the summons yet because you just filed the complaint and now you're trying to get them to waive it. So the first thing you got to do when you figure out they're not going to do it is go back down to the clerk's office with the summons for the person who did not accept it. Get the clerk to stamp it and sign it. And then you've got to get that into the hands of somebody who's going to track down that defendant and get those papers into their hand. And you've only given them 30 days to do it. So how long do you give them?
One day.
I like one day.
5 days.
One day you can't even get it to them in the mail. Remember,
I don't know, maybe 14.
Rule 6, the 3-day mailbox rule. They'll have it in 3 days, theoretically. I'm still waiting on a green card that I had served by certified mail, and it's been 2 months since I sent it out. And 2 months since the defendant signed for it, and I'm still waiting on that green card. So how reliable is our postal service?
And our clerk's office, they don't agree, we filed something in June, it was served on August 20th, and we just got the notice of service yesterday. So
Because the clerk's office is behind. Yeah, the clerk's office is behind in getting the information entered. So how long do you wait? And that's going to be a judgment call for each of you. It depends on your practice, who the defendant is, how much time you reasonably think you're going to have. Here's the way that the waiver of service actually works. When you send a summons out, you know federal court is going to be 28 days. It used to be 30. But then many years ago, they changed it to where everything was a multiple of 7. And so they dropped it down to 28 so that it's exactly 4 weeks from when you get the papers is when you have to serve an answer. That's one of the key things about federal court now is most all the deadlines are, most of them, not all of them, are based on a multiple of 7. So if you are prepared to have this, prepared to go down and say, okay, you've got 28 days to answer. If you wait 60, and then you give them 28 days to answer, your answer is not going to come in until after your 90 days is run. That's okay, though, as long as you get them served, right? So how long do you give them? It depends. That's your best answer. Yes, ma'am?
In federal court, is there a motion to serve by publication?
There is. We're coming to that. Ms. Wells.
So you said it was 90 days in federal court, which is 120 for state court?
120 in state court.
So you see the case that we filed in June, it took July, August, September, but we got notification. That's 3 months right there.
Which is your 91 or 92 days.
Yeah, but I mean state court, so we had another month.
Yes, ma'am.
What if you don't have a good last name address?
Then you keep trying. And that would be good cause if you don't have an address to go ahead and have a process server try to track them down. Oh, they have this thing called skip tracing. Usually you go to a debt collector's attorney and say, hey, look, I'm having difficulty finding this defendant. Can I borrow your resources to find out where they may be? And they'll come up with a list of all the different places they've applied for credit cards and opened up bank accounts. And that, then you can try to each one. There's another thing I need to tell you about a summons. And I had one of these just recently, a divorce case. And the wife moves out of the marital home and moves, she says, home with her parents in Ohio. And he moves out of the marital home back to Alabama with the child. She didn't have contact with the child. He moves here. You got to wait the 6 months for Alabama to be their home state. And then you file for the divorce so Alabama can decide custody. So she says, I'm living up here in Ohio at my parents' house. So we send summons and complaint up there, certified mail up to the parents' house. Comes back as undelivered. And the mom actually answered the door and looked at the mail and said, oh, it's from some attorney in Trustful. And told her daughter, oh, we just told them you don't live here. So the post office sent it back. So the wife calls up the husband and says, what's some attorney in Trustful doing sending me letters? Are you trying to finally get a divorce? Yes. Where do you live so we can get you the papers? Well, I'm over here in where should I say, North Carolina? Big difference between Ohio and North Carolina. So we resend those papers back out. The problem is the court has got her original address as being in Ohio. And that's what the summons has the address in Ohio. So So now that I've found a new address, can I have that same summons issued to her? You can't. You've got to have a new summons to issue. And the name of that summons is called an alias summons. And that's just the second summons that goes out. Now what happens if that address wasn't any good either and I finally track down the real address? It's a third address. You got to do another one, so what do you think you call that?
Alias 2.
Alias 2, I like that answer. The state court system is not set up to actually call them by their proper names. They still call them alias summons, but the proper term for the third one is called the pluries summons. P-L-U-R-I-E-S. But yes, in the state filing system, it's just another alias. So you can call it alias 2 and then alias 3. And that's kind of the difficulty you have in tracking down some defendants. Now the best part of the story is, after they've been separated for so long, oh, by the way, I'm pregnant. Not his. So now the whole divorce is on hold until she has the baby and we get DNA to show it's not his baby.
Is it not her job to like keep her address current with the court?
To keep her knees together.
Well, that too. But her address current.
It is her duty to keep the court currently apprised of what her address is. Well, I'm not going to just blame her. It was the man who wasn't her husband's fault too.
Well, that's true. She was trying to stay in North Carolina.
So prior to serving, you can't file an addendum. Prior to serving, it has to be a new one from scratch.
Well, it's called an alias summons because you're changing the information and then having it to reissue. Systemically, the way it's set up to issue an alias summons is you get a copy of the defendant's information again. You can go and make address corrections, and then when it prints back out, it says notice to defendant, and it's got the new address. So if you need another one after that, you do another alias because it is the only way you can change their address on it and get that address still with the court system. All right, any questions about, the waiver? Let me tell you the rest about the waiver. If you serve the summons and complaint, you have 28 days to answer the complaint. However, if you waive service, you have a reasonable time. And this is how it works out to give you more time. You serve the complaint along with your notice of your waiver. And they have the complaint in their hands. Within a reasonable time, they're supposed to sign it and send it back to the plaintiff to be filed with the court. When it gets filed with the court, the waiver of service, that's when the 28 days starts to count. So it could be a week, 2 weeks that they have extra time to investigate the complaint and have time to draft up an answer which reflects actual investigation rather than a defendant coming to you on day 28 after getting a summons and saying, I need help, and you have exactly 2 hours left to answer their complaint. Sometimes that delay makes us have to do things on short notice. So the time answer for a waiver is actually under D3. A defendant who being served before timely returns a waiver need not serve an answer to the complaint until 60 days after the request was sent or 90 days after it was sent to the defendant outside the United States. So they actually give them, instead of 28 days, they give them 60 in the U.S., 90 outside. Plus that extra time that's in their hands before they send the waiver back to the plaintiff's attorney. The results of filing a waiver, it does not waive any arguments that they have. Under 5, waiving service of the summons does not waive any objection as to personal jurisdiction or venue. By the way, you can't waive subject matter jurisdiction either. The court has to take notice of subject matter jurisdiction all on its own. They call that ex mero moto, M-E-R-U-M-O-T-O, M-O-T-U, motu. It's on the court's own initiative. The court has to notice it doesn't have that. I'll give you an example about when a court would notice that. If you file a complaint alleging diversity, but then both the plaintiff and the defendant live in the same state, the court has the opportunity to notice that on their own and say, we dismiss it for lack of subject matter jurisdiction because it's not really diversity. So you have a job to make sure you pick the right court, but the court also has a job to make sure that they have the authority to enter an order.
What's that called again?
Ex mero motu, M-E-R-O-M-O-T-U. Yeah, 2 different words. Well, 3 words with X on it. Bless you. All right. Any questions on that? Yes, ma'am.
So, if the example you gave, if they you have to serve it in the hands of the person?
Oh, we hadn't gotten there yet. We're still on waiver. If you send it to them with that form waiver letter that says, if you accept this, you have more time, and they, by rule, they get at least 60 days if they're in the U.S. rather than the 28, and then they have a reasonable time to get that waiver back to you. So how long do you wait? If you send it out the same day that you filed the complaint, what's a reasonable time? 7, 10 days? 2 weeks? It all just kind of depends. You know it's got to go back and forth in the mail, which is going to be 3 days each way minimum. So you give them a reasonable time to get that back to you. It gives them automatically 60 days in the U.S., 90 days if they're outside the U.S. to answer your complaint. If they don't send that waiver back to you within a reasonable time, then you've got to get them served within that 90 days. But the good news is, whatever expense you incur in getting them served, if they've not returned the waiver, then you get to send them a bill for it. And if they don't pay it, you get attorney fees to write them a letter, or to file a motion with the court to order them to pay it. That's the waiver. Everybody got waiver? Only in federal court, not available in state court. All right, now, serving an individual within the United States. And this is 4E. And then we'll get to outside the United States. Unless federal law provides otherwise, an individual other than a minor or an incompetent. So I guess we're going to rephrase that to say a competent adult, or a person whose waiver has been filed. So the waiver is the exception to all of them. May be served in a judicial district of the United States, bless you, in a judicial district of the United States by following state law for serving a summons in an action brought in the courts of general jurisdiction in a state where the district court is located or where service is made. Notice that all that says is I can serve them in federal court according to state rules. So federal court has adopted all the means available for service in state. They've adopted those for federal. Now, in my list that I build up, in my summary that I do, I usually put that one last. Any other method available under state law. So let's go to the rest of it. Number 2, doing any of the following. Delivering a copy of the summons and the complaint to the individual personally. How do you deliver something to somebody personally?
Email.
You hand it to them. You put it in their hand. You have given it to them personally if your person hands it to their person. So that's number 1 for federal services. Deliver personally. Number 2, leaving a copy of each, which is one of the summons and one of the complaint, at the individual's dwelling or usual place of abode, with someone of suitable age and discretion who resides there. The state rule says to leave a copy at the individual's dwelling house or usual place of abode with someone of suitable age and discretion who resides therein. Do I know what the difference between those two are? There's not one. It's the same. In federal court, you serve them by giving it to them individually. In state court, you do the same thing. In federal court, you leave it at their house or usual place of abode, their residence or usual place of abode, to a person of suitable age and discretion who lives there. It's the same in state court. And then number 3 is to give it to their agent. Whoever their agent is, whether it's by law or by designation, you give it to their agent and you've got them served. Use a corporation as an example. Every corporation that has authority to conduct business in the state of Alabama has to have a registered agent with the Secretary of State. Y'all know that, right? That registered agent, you know what their job is?
To receive summons.
To accept summonses and complaints. In fact, there's a business down in Montgomery called Corporation Company. That's all they do is they accept service of summons and complaints, and they take those documents and forward them to the company, wherever they're located, anywhere in the world probably. They just accept it inside the state of Alabama and then forward the paperwork on. Now, when I was sitting in the seat that y'all are in, when I was in law school, I had a job working for David Rogers, who was the standing trustee for Chapter 13 in the United States Bankruptcy Court. And as a standing trustee, he has to be the person who decides what to do with the debtor's money. So he's actually appointed by law to handle the financial affairs for people that file for bankruptcy, for Chapter 13s. Well, in his capacity to do that, sometimes he gets certified mail. Well, me hired as a runner, what do you think my job was? To run between buildings, to go to the post office and pick up the mail, to go to the courthouse and pick up all the papers that he's supposed to have from the courthouse, to go to the courthouse and file all the papers that he wants to have filed in each of these cases. So you run from one place to another. The key one is, I go to the post office to pick up his mail. And what do you think he has in the mail? Certified mail. Now, if I go to the post office and pick up all the mail but certified because he's got a sign for it, remember the little green card? Then that really defeats the purpose of having a runner. So the Postal Service has this form, it's called a power of attorney. And you fill out the form and he says, John Bodie is authorized to sign for certified mail for me. The post office keeps that on file. What do you think that just made me?
His agent.
His agent to sign for certified mail. So you've got either somebody appointed by law, like the Secretary of State's registered agent, or you have somebody appointed by power of attorney as to being the person who can accept those. And then, of course, take them to the office, open the letters up, and then put the certified mail on his desk, and all the other mail on the Secretary's desk.
So if you did not sign the power of attorney,
Then he would have to go to the post office and sign for it himself.
what if the post office, what if you sign for it? Let's say that the person serving the summons, the person who's filling it out, they fill it out correctly, and they mail it.
Well,
Certified receipt,
they mail it, and it's addressed to David Rogers at his address.
right?
Okay.
And it goes to
They send it certified mail. We'll get to that when we talk about how to do it in state court.
okay, they send it to certified mail, but it goes to the, not B, because that's the dwelling house, but it goes to
Goes to his office.
and the secretary signs for it. And they read.
Is the secretary authorized to sign for it?
What would give the secretary authorization?
Another power of attorney filed with the post office.
So if there's no power of attorney signed with the post office, the secretary routinely sign these things. So does that mean that there wasn't proper service?
Let me answer that with a case. Bigham versus Bigham, B-I-G-A-M versus Bigham. And this is a case where the wife was served and somebody signed papers for her. This person's name was Chang. And they went ahead and got a default judgment against her because they didn't know about the lawsuit to file an answer within the proper number of days. And they said because service of process in this case did not comply with Rule 4C1, we conclude that the trial court erred by denying the wife's motion to set aside the default judgment for lack of personal jurisdiction.
Wait, say that again?
Alabama law requires strict compliance with the rules governing service of process. They also require strict compliance with process. So the person who signed for the wife's letter at work, there's another case where this man's secretary signed for him. Not valid because they didn't prove that she had the power of attorney to sign for the summons and complaint.
Is there a time period why the wife would have had to appeal that? She never knows about the notice. Now there's a default judgment. She doesn't know about the default judgment for 4 months, 6 months. Is it like a 4-month period and then?
There's a time period, and we cover that next semester. Right now, we're just trying to get them into court.
Okay, sorry.
No problem. Yes, ma'am.
So like if the wife son or wife son or the husband is supposed to be getting served, they would have to, because they would just go back to court and say they've been served, they'd have to raise that.
Oh, well, let me tell you about one and see if you think this is good service, okay? Because we know delivering it to their house.
I think it's good service if you're
Hold on.
to their house.
We deliver it to their house to a person of suitable age and discretion that lives there, okay? We'll get into all the rest of these components in a minute, but we're just going to give an example. I got a case that was filed out in Vesper, family court case. This husband and wife are taking care of their nephew. And they file a petition saying that the nephew needs somebody to take care of him because daddy's not doing it. And so they filed the petition to get custody because daddy's not taking care of his child. Well, guess what? Daddy lives with them. So the aunt files a complaint in family court saying, Daddy's not raising his child, we want custody. And they say, okay, go ahead and serve it. And the sheriff's deputy comes out to the home and leaves it with a person of suitable age and discretion who lives there, who happens to be the petitioner.
Oh, wow.
All right, now, is that good service of process under the rule? Did they not deliver it to somebody of suitable age and discretion that lives there?
Yes. And she could throw it away and win.
And she could throw it away and win. And she could throw away the summons and complaint and win.
Yeah.
So, I mean,
Wow.
it'll be easier.
Does it technically comply with the rule?
Yes.
Okay. My argument in court was it doesn't pass the smell test. That was the exact words I used. I said, Judge, this does not pass the smell test. They ordered the father to be personally served. Now, it turns out I was the child's guardian, but, you know, if I don't know that Daddy didn't get notice of it, and magically after he got served, he showed up to court. He didn't the first time because, well, we're not going to assume that. Remember, a summons and complaint delivered to their residence to a person of suitable age and discretion who resides therein is supposed to be notice reasonably calculated to give a person actual notice of the pendency of the lawsuit.
Well, see, you don't want the secretary because it looks like, because I sign things all the time, but if I'm getting this and I'm signing this for my boss, it should be, I should have the duty to say, hey, I'm not his agent, let me get him.
Okay. And let me ask you this. What if he goes ahead and files an answer anyway?
Well, he's accepting it. I mean, he's
If he had an objection to it
I got you.
and he fails to raise it, it's what? There you go.
But if he goes ahead and accepts it and answers, he is submitting to the case and jurisdiction.
He's waiving those things.
But how can he waive if he wasn't informed?
Well, he got his complaint and filed an answer.
Yeah, he answered.
Oh, if he answered?
Yeah.
Okay.
Yeah, he answered and didn't raise an objection in there,
No, I was
so.
saying if he did that. I got you.
But no, I mean, I didn't even know about this power of attorney thing when
Yeah, with the post office. They've got a form for it.
signing for him.
Has he waived any of it?
No.
Every bit of it, right?
He's just taking it.
Yeah. But remember, you got to strictly comply with the requirements, but then if you have an objection and you fail to raise it.
Really, if you object to it, all they do is call their alias and get them first and served.
Yes.
It's a time delay.
Yeah, but what about that example about the aunt accepting service on her
Well, I
brother-in-law?
like how you did that, because that wasn't unfair.
Well, and what do you think fairness deals with? It's due process, right? Due process, isn't that notice reasonably calculated to give the person actual notice of the pendency of the action? And so while it strictly complied with the rule, it did not comply with due process. So a judgment entered without complying with due process, that's void. It's not a good judgment. So you've always got to be ready to spot due process issues, even if they do strictly comply with the rules. Because remember, a judgment entered without due process is not going to be a judgment worth anything. And I thought, as soon as that happened, I thought, this is a great teachable moment. I'm going to tell people about this for the next 20 years. Because it was just wrong. All right, so let's get back to serving the individual within the judicial district. And I want you to write this down in your notes. Service of process is, number one, delivering it personally to the individual. Number two, leaving a copy at their residence or usual place of abode with a person of suitable age and discretion who lives there. Number three, delivering it to their agent. Or number four, any method approved by state law. That's why I put it at the end, because it's a catch-all. And there are some other methods that are approved in state law that aren't allowed under the federal rules. Yes, ma'am. Number two, leave it at their residence or usual place of abode with a person of suitable age and discretion who lives there. And if you're looking for that wording, it's on page 3. It's 4E2B. 4E2B.
What was the one you said in a method?
Any other method acceptable under state law.
Where does it say acceptable under state law?
That's under E1. 4E1. Did you find it? Got it? That's service of process. Now, let's talk about if I don't strictly follow one of those methods of putting the papers in their hands or leaving it at their residence or deliver it with an agent or any method accepted under state law. In other words, how about I send it FedEx? Is FedEx one of those ways listed? That term is called insufficient service of process. Now, I want to point out to you in your notes, it's not insufficient process of service, it's insufficient service of process. And every year I have one person who gets that wrong. Process of service, at least one. Call it the right thing, it's service of process. And if it helps you to think about it, it's service of the paper or service of the summons. Because the summons is a form of process. It's service of process.
Insufficient service of a process.
That's it. Insufficient service of process.
If it doesn't meet one of these four.
If it doesn't meet one of those four, it's insufficient service of process. Now,
Okay.
yes.
Question. So you said you get a student who gets it wrong. Does that mean like the multiple choice question is?
No, when they write the essay question out,
Oh.
they'll say insufficient process of service.
Gotcha.
And it's like, ooh, that's wrong. I don't even have to read the rest of it.
Oh wow. Okay.
Because you don't call it the right thing, I don't know what you're talking about. Bar examiners do the same thing. In fact, let me give you a pointer on writing your essay answers. Underline these key terms that I'm telling you about, like insufficient process or insufficient service of process, or get you a highlighter out, highlight it when you write it, or if you're typing it up on ExamSoft, underline it so I know that you're directing my attention to it specifically, because that's what the bar examiners look for is, I am pointing this out to you. Here's the key term, and I'm using it properly. That's really what they're looking for. And number two, that you make an actual good argument. So that's a test pointer. Now, let's get to the rest of process. Remember we said process is both, well, no, we can't do this. To their residence or usual place of abode, with a person of suitable age and discretion that resides therein. What is suitable age?
Age of majority.
All right, let me give you a hypothetical. What if I've got a 17-year-old who's a senior at Jefferson County Baccalaureate, who's taking all college classes, because they do that out there, and I come, knock on the door, and hand the summons and complaint over to the 17-year-old who's a student at International Baccalaureate, who's on the honor roll out there, and say, give this to your mom or dad. Is a 17-year-old suitable age?
No.
Still a minor.
Doesn't that vary with our
They have to be 18 to be, well no, they have to be 19 in Alabama to be an adult.
Still a minor.
But is an honor student taking college classes suitable discretion?
But you don't know that.
You could make the argument that this person is suitable age and discretion to know, hey, these papers are important, make sure your mom and dad get them.
But you would have to know that about, like you wouldn't know that. If you walked with my daughter, you wouldn't know nothing about her.
All right, let's give you an easier one. How about little 5-year-old daughter comes and answers the door, and you say, well, hello there, would you give these to your mommy or daddy? Now, is that either a suitable age or suitable discretion? All right, I think that was pretty easy, right? That 17-year-old is an it depends, right?
Yeah.
They may or may not be suitable. How about another one? This ought to be an easy one for you. I've got a 30-year-old who's still living with mom and dad.
Yeah, they cool too. I first 17-year-old
All right. Can you leave the summons and complaint with a 30-year-old who's still living with mom and dad?
Yes.
Yeah.
Really?
Yeah.
What if they have cerebral palsy and the reason that they're living with mom and dad is because they're unable to take care of themselves and unable to communicate?
Yeah, so it's a, it depends.
Good question.
It is and it depends. And it depends on age and discretion.
Right.
They got to be a suitable age. 5 clearly is not. 17 might be. 16 or 17 years old might be. You can make the argument. 30 definitely, unless they've got some reason why they're still living with mom or dad. You know, all of it's, and it depends. It depends on what you can convince the judge. So here's what you've got to be able to convince the judge. And this is what due process is. You have got to convince the judge that the method that you used to deliver the papers was reasonably calculated to give actual notice to the person that's being sued of the pendency of the lawsuit.
actual notice.
That it's got to be sufficiently now I've forgotten the term I used.
Reasonably calculated.
Reasonably calculated to give actual notice of the pendency of the lawsuit to the person against whom the summons is directed. Now, if you use that as your test for all of these cases, then you can say, is delivering it to a 17-year-old who's an honor student, senior at the International Baccalaureate School, who's probably got more sense than mom and dad, is that reasonably calculated to give mom and dad actual notice? It just has to be reasonably calculated, right?
That's where I went to high school. I would have.
We'll let you slide on that one. All right, so there's your ultimate test on it. Reasonably calculated to give actual notice about the pendency of the action.
What happens when you're approaching someone to serve them? They are aware they're getting ready to be served. You whip out the envelope, the person puts their hands in their pocket.
Oh, did y'all hear that question? What do you do when you walk up to somebody and they see you come with papers in the hand? So they put their hands in their pockets and lock their arms tight up against their body. And they stand there and they look at you and they say, okay, are you Mr. Smith? Yes. I've got some papers for you. I ain't taking them.
Shove them in their mouth.
That might result in a criminal charge. What do you do?
Drop it at their feet. Tell them that you gave
Do you drop it at their feet?
Well, it has to touch their person.
So hit them with
It has to touch their person. Who said that?
Me, I don't know.
What is the test for whether or not it's good service or process? Is it reasonably calculated to give them actual notice? Well, is it reasonable to drop it on their feet if they've got their arms locked up tight against their body
if they confirm
and
that
they know
who
that
they
you're
are.
trying to serve them papers?
Yep, you're on the absolutely.
And then you get a declaration.
I think if you take that issue before a judge, they'll say that that was reasonable under the circumstances to give them actual notice about the case.
Can
Yes.
you record that with your phone and then show that to the judge?
Oh, absolutely.
Okay.
You can record it with your phone so the judge can see, yeah, he tried. Now, let me tell you about my friend Jeff. He's a lawyer now, but when he was in law school, he worked as a law clerk for one of the professor's firms. One of the professors that works here or used to work here. And they were a plaintiff's firm. And they would represent people in personal injury cases. Well, he got asked to deliver a summons and complaint because he was eligible to do that. He was the right age, etc. And we got to go back and cover that. To deliver the summons and complaint to this guy. So he went by this guy's house. It was a trailer. I remember him telling me this graphically, because when I told him I use your story in class, he just laughed and told me the rest of the details. It was a trailer. And he got to that guy's place and was parked at the curb, and the guy pulls into his driveway. Jeff goes ahead and gets out of his car, starts walking to the guy sees him, and he runs into the house and locks his door. Now, is that a good attempt at service?
No, because he just walked up on it. Not yet.
Not yet, right? So what's he got to do? He's got to try again. So a couple of days later, he decides, okay, I'll try again, but this time I'm going to catch him going to work. Because I know he'll run in the house and lock the door. So he parked, I think, down in front of the next door neighbor's house, where he could see the front door of the trailer. And when the guy opened up his door and started going to his car, Jeff got out of his car and started jogging up to this guy. The guy saw him. He ran and got into his car and locked his door. Now, is he avoiding service?
Absolutely.
A lot of people do. So he was scratching his head, what can I do, what can I do? He finally came up with this idea, well, I need to drive a different vehicle because now he knows my car. But he had a pickup truck too, so that was okay. He said, I need to be doing something to draw his attention without seeing me coming. So what he did is he put his lawnmower in the back of the truck. And as he was driving down to this guy's house, he was noticing the names off the mailboxes. He knew the defendant's name. Say it was Jones, but he drove by and saw that there was a Smith. So he got up to the guy's trailer, parked, got the lawnmower out, and started cutting the man's grass. And Mr. Jones comes out and he says, what are you doing? He said, I've been hired to cut Mr. Smith's grass. He says, I'm not Mr. Smith, I'm Mr. Jones. He pulls that paper out and says, you've been served. Now,
But what, the guy cannot sue him for trespassing?
and for cutting his grass.
Wow.
Yeah. And there were signs posted, no trespassing. Yes, ma'am.
That's funny, the guy we use does landscaping, so he pulls up with his stuff, so whoever he's serving thinks he's looking for a house. I mean, it's perfect. I mean, he tells me that. He'll
It's
come
a
up to them and say,
perfect-
hey, I'm so-and-so, and then they'll introduce themselves. They think he's looking for a house.
Was he one of my students? So anyway,
But I give you that.
One of the things you've got to learn about service of process for the civil world is that you cannot use trickery to get them served. Yeah, you can go up and things like that, so it's not actually lying to them to get them served. You can't lie to people and get them served in the civil world. To give you an example about how they do that in the criminal world, they'll take a list of people that have outstanding warrants, and they will send them a letter in the mail that says, "You've won 2 tickets to the Alabama Auburn football game."
That works.
I remember they did that
Well.
here.
They do that here in Birmingham on a pretty regular basis.
Oh, yeah.
And what they'll do is they'll get a news crew down there to film them, and they'll have all these deputies dressed in plain clothes in the hallway that are just clapping for them as they walk in. And when they walk into this room, they serve them with their warrants. And it's usually deadbeat daddies, I think.
Didn't they say one about car contest when they all showed up to do the car contest?
Yeah, and police can actually lie to you. The U.S. Supreme Court has said they can do that. So it's not a flawed service to get them served or arrested on warrants, but you cannot use that type of stuff to get them served civilly, because if you're going to tell them that, oh, you've won something, if you want a chance to win, then you better be having a drawing on it, or otherwise they can say it was a ruse to get me to accept service. Yes, ma'am.
In the same story, wasn't there a gentleman that sent his brother in to collect the ticket?
There was. I saw that a couple of years ago.
Yeah, and what did they do? Because it's not him.
I don't know what they did. They probably said, well, he has to be here personally.
I don't know, but if it's too good to be true, it probably is.
Yeah, if it's too good to be true, it probably is. So let's look at I'm trying to find the specific. All right, service of process is personally, residence, suitable age of discretion, I think we've covered, with somebody who lives there. Here's another example I love to give in class. What if I've got a big yard and I've got a landscaper that comes by on a regular basis, or I've got a gardener. I've got somebody I actually hire as a gardener to take care of my yard because I don't have time to do it. Process server comes up and delivers the summons and complaint to my gardener. Is that good service of process?
No.
You'll have enough facts to make that decision. Because what if my gardener actually lives with me in a spare room? Right?
What if the one that doesn't speak English doesn't know what he's getting? He throws it away.
That doesn't matter if they speak English or not. It matters whether or not they live there. See, the test is whether or not they live there and they're of suitable age of discretion.
Oh, no.
Time to go home.
Yes, Pat?
I can still hear you. Keep on going.
I think one of your classmates has an unfair advantage. So it's whether or not they live there. Now, what if the gardener actually has a mother-in-law's house or a mother-in-law's apartment that's actually on the same property?
I would say live there. They live there.
You would say live there, right? And then what if
Apartment A, apartment B, though, I mean, if they're considering
it may, it's something that you can argue, but it's got to be somebody who actually resides there, suitable age and discretion. Now, there was another one, I saw a case on this, where a guy was having an affair with his secretary, and every Wednesday night they went to the same motel. And spent the night, Wednesday night, every week. Is that a usual place of abode? Can you not make that argument that it's usual because it's his Wednesday night thing?
I think you could argue.
But he didn't have any discretion.
Yeah, they didn't have discretion. I love that.
Know it was a usual place of abode.
Well, he had enough discretion not to do it in his own marital home. All right, go back to C. Go back to letter C because we did skip that. We did get A, the contents, and the B, the issuance, that it's got to be signed and sealed by the court. Letter C, and this is part of the procedural process. So if there's a defect in this, it's insufficient process, but it's a procedural defect rather than a substantive where it doesn't include all the information it's supposed to. And that is, summons must be served with a copy of the complaint within the time allowed by Rule 4M, which we already know is 90 days. In federal court, it's 120 days in state court. And then by whom? Here's the important thing. Any person who is at least 18 years old and not a party may serve a summons and complaint. Yeah. Hold on. Hold on, this is federal. In federal court, it has to be anybody over 18 and not a party. And then if you look at Rule 4, I think it's I1B, 4I1B. It's on page 6 of your rule book if you're looking for it. Methods of service. Service under this rule shall include the following. In state, it's by sheriff or constable. And then number 2, by a designated person. It says alternative delivery by sheriff, or when a person is to be served personally outside of the state. They may be served by any person not less than 19 years of age who is not a party. This is I1B.
But that's state, right?
Little I, yeah.
We have it after the bar class. It's looking at stuff for the bar.
It is all stuff for the bar.
The state stuff too?
Yeah.
Oh, you said that's state.
Well,
It's federal, but there's
the state stuff is an online thing that you have to take, that you have to have completed also by the time you finish the bar exam, that you have to have not only the NPRE, but you got to do the state online thing.
Okay, we have a good one.
Oh yeah, it's an online thing.
You have to pass the first
But
part
it's
first.
not,
That's one you have to do.
it's not like an act where you do it like the city. You do that.
Yeah, most people do it right after the bar. All right, so under I1B it says somebody over 19 who is not a party and not related within the 3rd degree by blood or marriage to the party seeking service of process. So in federal court it's just over 18 and not a party. State court is over 19, not a party, and not related within 3 degrees by blood or marriage. So what if they have effectively eliminated in this? Your kids can't serve your spouse with the summons and complaint. And neither can your grandkids. And neither can your brother-in-law or your aunt and your uncle. They've separated out by at least 3 degrees. Now,
So foster kids can.
That's what she said at Christmas and things.
hey, that's a pretty good rule. If you see them at Christmas or Thanksgiving, then you can't serve them. Except, I heard somebody use the term Friendsgiving last night. Y'all know what that term is?
What was the term?
Thanksgiving with your friends. We do that at the beach every year.
Yeah.
Okay, Thanksgiving with your friends? All right.
It's for the people who don't have family. Not everybody can go home. Still, they don't like
Tom? What? No, it's 4I1B in state rules. State rules. Question. 4I1B. And it's over 18 and not a party. Now, my viewer didn't come back on.
You got, where's the remote? The other, like, well, it's flashing. It's on standby.
This may be over here. No, that's somebody's recorder.
Oh, there we go.
Oh, good. All right, so procedurally, let's go back to Rule 4 as to who can serve it, because this is the procedural part of process. you've got that it's got to have all the required information on it, signed by the clerk and sealed by the court to be substantive. Procedural, it's got to be delivered by somebody over 18 and not a party, and this is back to Federal Rule 4C2. Number 2, by Marshal, that's U.S. Marshal. Well, the comparable position for that in state court is the sheriff. So it's individual, federal court is 18, state court is 19. Both of them are not a party, and then in state it's additional, you can't be related within 3 degrees. And then for law enforcement, federal court is U.S. Marshal, for state court it's sheriff's deputy or constable. We haven't gotten rid of all our constables yet, but that's still happening. And then someone who is specially appointed is the last one. And what that is you actually file a motion with the court to appoint somebody specially to serve the summons and complaint, and they have a court order. And typically when you do that, you don't just serve the summons and complaint with that, you also serve a copy of the motion to appoint that person and the order appointing them so that the defendant knows this person's been specially appointed to serve these papers. Again, it's notice and the opportunity to be heard. Now, that's the procedural part of process. You got to have the right papers, and it's got to be delivered by the right person. Over 18 or over 19, not a party, and state court, not related. Law enforcement, which is U.S. Marshal Federal, Sheriff's Deputy, Constable State, and then any other person who's specially appointed, and that's the same in federal and state. Now, if I take a summons and complaint, and I decide, oh, by the way, number 4 is any other method authorized by state law. That's number 4 in federal, is any other method authorized by state law. And the reason that's in there is because we have this thing called certified mail. We also have something called publication. And then there's also the opportunity to serve them by regular first-class mail if you meet the requirements.
What about email? Because it has like receipts where you send it.
Some courts have accepted email.
We're checking. Because it says
Any other methods is in state law?
Any other methods accepted by state law.
Where did you say that?
Look at 4E1. Follow state law for serving the summons.
Yes, word that. Okay, so that still applies to...
It still applies to who gets to deliver it, yes.
Still applies to...
Yes.
Okay.
All right. We've covered... Oh, why do you think Alabama changed it to 19?
That's age majority.
Age majority. And then taking out the third degree of by blood or marriage to keep relatives from getting involved in court proceedings. So it looks like it's fair. You got the appearance of fairness. All right, serving an individual within the United States is 4E. Serving an individual in a foreign country is 4F. Now, there are 2 different possibilities of serving a person in a foreign country. Well, 3. Let's use 3. I'll give you an example of one I did. Without even looking at the Hague Convention, which deals with service of process in a foreign country, I sent an international certified mail to this guy's child who lived in Italy at the time, with a copy of the summons and complaint, and she went ahead and filed an answer. Now, does it matter how you serve them if they turn around and file an answer and don't object to how they were served?
No.
It does not matter, because if you fail to raise it, it's what? There you go. How many times have y'all heard that today?
At least 3.
If you fail to raise it, it's what?
waive.
Y'all need to get used to that. If there's an objection to any of this, which has to be strictly followed, if you don't raise the objection, it's waived. So although the Supreme Court says you have to strictly follow it, so many people don't raise an objection to it that it doesn't matter because it's already been waived. Yes? I'll give you another example. I had this lady come into the civil help desk this week. Attorneys are supposed to do volunteer work, volunteer time, pro bono work. So I went down and sat at the help desk Tuesday morning. And this lady comes in and she's got this judgment evicting her from her apartment. I said, tell me about this. So she said, yeah, I just got this thing in the mail. I said, you didn't hear about any other way before that? She said, no. She said, and I called this lawyer that said, call. I said, what'd she say? She said, I'll see you in court. Okay. Tell me about what happened. Well, she said they posted a notice on my door.
Yeah.
There wasn't no notice on the door.
That's all we take a picture of.
They didn't take a picture of it because they didn't do it. I said, okay, and what else happened? Well, the judge entered a judgment awarding dollar money for an eviction because she hadn't been served with the summons and complaint. I said, ooh, they don't have personal jurisdiction over you. And not only that, they didn't serve you with process. So we made a special appearance to object to process and to object to service of process because they didn't deliver it properly. And then objecting to personal jurisdiction because, as you're studying for next week's class, if you don't do it right, the court doesn't acquire jurisdiction over the person to make a decision that's going to bind them. So I said, for the limited purpose of doing this, and then, that's another one?
About the limited purpose. They had just filed an appearance and answer.
Uh-huh.
They were
And that's what the first attorney had drafted up for her, was an answer which didn't raise any of these things. And I said, oh no, don't file that. Because if you file this, you will have waived these things I'm writing up for you.
So you did a notice, a limited notice of appearance.
Did a limited notice of appearance as objecting to process, service of process, and personal jurisdiction.
But if you had done an appearance
Get up, girl.
and an answer, that's the story I was going to tell you in class.
And then, the next thing I told the judge is, you didn't have the authority to hear this case. Because the notice wasn't posted on my door, you didn't have in rem jurisdiction. And because you didn't serve me with the summons and complaint, you didn't have in personam jurisdiction. And therefore, this judgment was entered in violation of due process and is void. So set it aside.
Does that lady have any idea what Professor got?
She was so lucky.
Yeah.
You told that to a judge?
Now, I wrote that in the motion.
Oh.
And yes, I would tell that to the judge in front of them, because if they don't have the jurisdiction to do something, they should have never entered the order. And if they rule against me, I'll take it on appeal and get them reversed.
You went to sidebar?
Huh?
You went to sidebar?
I would not sleep on that.
Sidebar.
Oh. Not if the judge calls us to the bench.
Oh, okay.
This isn't in front of a jury anyway. It's possession of an apartment. Yes, sir.
Can you say everything surrounding not filing an answer? Again, I think everybody would definitely need to put that in their pocket, but it may have got lost in.
Oh, about making a special appearance?
About not filing an answer because of what filing an answer can do if you were not served properly.
Oh, it waives it. Did y'all get that? If you fail to raise it, it's what?
Waive.
I think they got it.
Okay.
If you file an answer and you don't raise that objection in your answer, it's what?
Waive.
There you go. So you put your objection in your answer. Your answer not only is whether or not you yes or no to all the things that are in the complaint, but it's also all of your defenses. And you make a limited appearance to object to all the different things that are wrong about how you got your papers. Remember, this is how to get them into court.
Right.
That's all today's lecture is, how to get them into court. And if they didn't do that right, the court had no authority to enter a judgment against you. That is due process, because the court has to strictly comply with these rules in this instance. And that's because due process requires notice and an opportunity to be heard.
Wait a minute. Say what you said one more time.
They have to strictly comply with these rules.
Well, you're saying that in your answer you do.
You make a limited appearance to object to.
You don't answer.
You You don't answer in general. You don't make a general appearance.
Okay, that's what I thought you was just trying to
No,
say.
no, no. You don't make a general appearance. You make a special appearance to object to.
Service.
Object to process, service process, and personal jurisdiction.
All right.
Because the court didn't have it if they didn't do this right.
Right. No response to the complaint.
No response to the complaint. You just say, I'll make a special appearance to say you screwed up.
Right, okay.
No process, no service of process, and no personal jurisdiction. Y'all got that? Because if you file an answer, which is a general appearance, you waive all of that.
Right, yeah.
Yes?
Do you think Alabama will ever approve use social media to serve someone?
I've seen judges already approve social media to use it. One judge that I know of has allowed somebody to be given notice by Facebook that you've got a case pending, you've got a hearing in this court on this date, and they approved it because it was reasonably calculated to give them actual notice of the hearing. And the judge says that complies with due process.
Had other attempts failed?
Yes.
So that was kind of like the last.
Yeah, it was the last ditch. Y'all got that?
With the discrepancy between 19 and 18, would not one of the arguments be state sovereignty to make their majority 18 versus, 19 versus?
Well, here's the thing. In federal court, you can use any method allowed in federal court, or you can use one in state court.
Okay.
So if in federal court you want to use an 18-year-old who's not a party, you're fine with that.
Okay.
But can you also use a 19-year-old who's not a party and not related within 3 degrees in federal court? Yes, because you can use an 18-year-old who's not a party, and even if they're related, you still can.
Just be conscious of it.
Alabama's just made it stricter in state court than it is in federal court, and they did it to meet the age of majority. All right, so everybody got that? Process includes substantive, which is the notice actually contains everything it's supposed to, and it was signed by the clerk, and it was stamped in by the clerk. And then it's got procedural components, process, where it's got to be delivered by somebody who's over 18 and not a party, by U.S. Marshal or a specially designated person, or any other method available under state law. If y'all haven't caught on yet, that is the summary that you need to turn in next week on process, both substantive and procedural for process. Now, for service of process, if it is a competent adult, then you serve them personally, or you leave it at their residence or usual place of abode, including Motel Cities, with a person of suitable age and discretion who resides therein. They regularly stay there, right? And then the other one is their agent or any other method available under state law. So let's talk about minors. How do you serve a minor? That's the next way in. Oh, foreign country. Y'all don't let me skip foreign country. I've got this on the board already.
Yep, you started talking about it.
If they're in a foreign country, I told you about sending certified mail and they didn't object to it. Here it is, and I'm trying to get this on the screen right. All right, your test about serving somebody in a foreign country is, first, is the foreign country a member of the Hague Convention? H-A-G-U-E. And as soon as I get this display to work again, y'all see it on the board. And then if the country that they are in is not a member of the Hague Convention, then it's a pain in the neck. And you've got to go through the United States Secretary of State, who will then contact the Secretary of State of that foreign country and arrange for service of that person in that country according to the methods of their law. And I'm not going to ask you to study 192 different countries' laws on how to serve people, because this is federal civil procedure. We're going to learn one. But if you're serving somebody outside of the United States who's not a member of the Hague Convention, then you need to contact the United States Department of State, who will then contact that country's Department of State, who will arrange for service according to their law. Now, if they are a member of the Hague Convention, then you're fortunate that it's an international agreement because this is technically a treaty. It is a treaty signed by all the member countries, which says, in service of papers in civil and commercial matters, this is what we agree to for all of our citizens to be served with notice of civil and commercial matters in a foreign country, which would be the United States. And projector, is it coming on?
Nope, still on standby. It's flashing. There you go. Coming on now.
Okay, good. The website that you need to go to for the Hague Convention is hcch.net. hcch.net. Okay, good. It's finally up here. And you can see that's the website I've actually got it on, hcch.net. You have a choice if you want to read it in English or in French or Francais. I'm going to pick English. And they do French because a lot of other countries, that's one of the languages that they use more frequently. All right, web page load up. And then it's got the instruments, which are all their different treaties. And they've got treaties for almost everything. You scroll on down here, see where it says service? They've actually changed this website. It's much more usable now. So this is for service of papers in civil and commercial matters. If you look at the full text, anybody else have slow internet up here?
You have a caution box on your connectivity on the bottom right.
No internet access.
Okay, there you go.
There we go. This is under the status table. I'll show you this. This lists each different country and whether or not they've ratified or approved or signed the treaty, and then what type. When you go over here to reservations, you can see and click on those that some countries may have signed with reservations. Let's go back to the actual text. There we go. What this does is pulls up the actual treaty itself that says these are the rules for getting people served. And what you can do is look exactly how they want to have people served, and then go back to your status and for your country and find out if they made any reservations, because sometimes they'll say personal service or certified mail. As an example, when you go to Mexico, they don't allow certified mail, they want personal service. So you go to the status, table for the country and find out if they've made any reservations. And then you read the text of the treaty itself to find out exactly how you can serve the papers. And it's separated out into articles.
Is this how you have to, is this for civil only or criminal?
Civil and commercial.
Okay, so no.
This is the treaty only for civil and commercial. And then they have others for child custody.
Okay. So like if you have a criminal that has fled and you want to extradite them back, you don't do this?
You don't do this.
Okay.
Not for extraditing criminals.
Okay.
So in this, it tells you which papers you can serve and how to get them served if they are outside the United States and this country is a member of the Hague Convention. So for your notes on summary, your test ought to be if you're serving outside the United States, is the country a member of the Hague Convention? Yes. Serve according to the Hague Convention? No. Contact the U.S. State Department and arrange for service through the State Departments. That's what you need to know for the exam and the bar. That much of it. The rest of this is just how to do it. And I'll tell you a nice little story, because every once in a while my students will actually call me back. And I had one call me back who's practicing down in Montgomery and said, "You wouldn't believe this, but I just made a nice fee, 6 digits." I said, "Ooh, tell me how." He said, "Well, there's this big statewide law firm down here that was contacted by this plaintiff trying to sue an international company and serve them at their corporate headquarters out of the United States." He said, "They didn't know how to do it. And so they couldn't collect the outstanding amount." So he said, "What I did is I went back to my civil procedure notes and found out, hey, we're the defendants outside the United States, follow the Hague Convention." So he looked, the country was a member of the Hague Convention. He went out to the website and found out, yeah, here's how I can serve them, because I think they served by certified mail, but it wasn't accepted because it's not valid under the convention. They had to serve by personal. So he hired a process server and got him served personal, and he got a judgment that was valid. And his fee off of it was 6 digits.
Wow.
Because he knew to look for this website and how to get the company served outside the United States. And that 6-digit figure is for a fee that didn't go to one of these big statewide firms. It went to a small firm guy. I love it when the little guy wins. And so next time I was down in Montgomery, he actually took me out to lunch. I wanted a third of his 6 digits. All I got was a darn meal. So that's what you need to know about service in a foreign country, is go actually to the Hague Convention if they're a member country, and then back on the status table, that's where you find the countries and whether or not they're a member. Let's go back and show you that so you can actually see it. Status table. All right, so what country do y'all want to look up? Canada. Canada's a member country. Here it is right here. Right there.
What are you looking at?
Letter D.
So
This line. So it's member. And then if you
so
want
like
to find out.
Bosnia is not in that box.
Yeah, if they're listed on here.
I just know what the letters mean. Like no letter means not a member. Letter means is there?
See if they put one down here at the bottom.
There we go.
There they are. Their signature, they've ratified, acceded, or secession to it. And then entry into force is when it became effective. And then look at number 7, reservations, declarations, etc. So when you see an R over here in the last column, like reservations, click on the reservations for Argentina. And it goes paragraph by paragraph through the treaty. Article 21, first paragraph, Argentina government designates the Ministry of Foreign Affairs, International Trade, and Worship as the central authority instead of their Secretary of State. So that's where they make changes specific to whatever their country is. And now you know how to do that. You go to your country, look at their reservations about what they do that's different from the actual treaty itself, and then follow that, and you get a valid judgment. Kind of simple, right? If somebody tells you about it. Now let's get back down to the actual summons itself. Down here at the bottom, return on service. Look at the second box. I certify that I personally delivered a copy of the summons and complaint or the other documents to this person, their address, blank county, and then they sign it. I saw a return on service come back yesterday. Just to tell you how good these process servers are, we got a service packet, which is the summons and the complaint, and then there was an ex parte motion in order that weren't signed. But so we sent the summons and complaint to a process server down in Florida. Called a friend of ours who practiced down there and said, "Hey, do you got a good process server?" They said, "Yeah." So we scanned it, emailed it down to this process server, and called the process server and said, "Hey, when can you do this?" And they said, "Well, 4 days is our standard, but if you want to pay for expedited, it's this much more." He got on the phone and said, "Well, let me tell you what, I know where this place is. It's on my way home. If you can get me the documents," and we already did. He said, "I'll stop there on the way home and see if I can get them served, and if I can, I'll just go ahead and do it and won't charge you for expedited." Within an hour of sending him the papers, we had the return on service that he had served the person. And then at the bottom where it says, "I certified that I personally served," they put all sorts of stuff. They put a description of the individual they served. 5'4", approximately 150 pounds, blonde hair, blue eyes, and described the person in great detail. Now, why do you think you might want to do that on a return on service?
It's the wrong look.
So when the person who's 5'4", 150 pounds, with blonde hair and blue eyes walks in the court and says, "It wasn't me,"
Oh, really?
sure looks like you. So your good process servers are going to do that kind of stuff. And not only that, they'll put down where they served them and the date and time. And sometimes they'll put weather conditions. They'll put all sorts of stuff on that return on service that will help them to remember. Because if they come to court and say, "I wasn't served," you're going to have to bring your process server to court to testify, "Yeah, that's the person I served." So it needs to be somebody who's credible. Now, in Alabama, before we changed it 2 years ago to be a 19-year-old, it was an 18-year-old. And if I put my 18-year-old process server on the stand, they're not an adult yet. So you know what they've got to do? Sort of. The judge has got to qualify them to make sure they know the difference between the truth and a lie. This is how you qualify a witness who's a minor. And Alabama said, "Our judges don't need to do that anymore, so make them 19 so they don't have to qualify." And the person gets on the stand and testifies. And then if the judge is convinced that this person got actual notice of the pendency of the case and that their method of delivery was reasonably calculated to do that, they're going to hold that the service is good. Have y'all got that? Reasonably calculated to give them actual notice of the pendency of the case. If y'all don't recognize that as a buzz phrase, you probably need to write that down now.
Say it one more time.
Reasonably calculated to give them actual notice of the pendency of the case. Pendency, P-E-N-D-E-N-C-Y. That it's pending. And if you use that phrase on your bar exam, they're going to look at it and say, "Oh, this person knows what they're talking about." Funny story. After the February bar exam, February of this year, during the bar exam itself, because now the bar exam's on Tuesday and Wednesday. Tuesday evening, I'm sitting at home and my Facebook Messenger thing lights up, and I look at it, and it's somebody I know is down there taking the bar exam. And I thought, "Oh, heaven help me." because that's a rough time. And I open it up and I look, and they're so excited to tell me that what you said was going to be on the bar exam was exactly what was on the bar exam. It's like, yeah. And I ran into them in court after that because they passed the bar, which is a good sign. And they said, oh yeah, I got a 5 on that essay. And it goes up to 6. 6 is the highest grade you can get on an essay. So when I ran into another one of my former students Tuesday night in night court, she said, oh yeah, I hated your class. But guess what? I got a 6 on my essay. I thought, well, you learned your stuff. Because you can't get any higher than that. So that's my feedback, that I know that I'm doing my job, is when I see my former students in court. It's actually good to do that. All right, so let's talk about a minor. How do you serve a minor? We're finally getting back to your question.
Service guardian.
All right, if you read the federal rules, it says a minor or an incompetent person in a judicial district of the United States must be served by following state law. So how do you serve a minor? Your answer for the bar exam and for this exam is follow state law.
Because it's different in each state.
It's probably different in each state.
So it depends.
It does. Now, actually, how do you serve them in Alabama? And when you go to 4C2, which is on page 6 in your rule book, 4C2 says, upon a minor by serving any one of the following: the father, the mother, the guardian, the individual having care of the minor, or with whom the minor lives. Now, you don't have to remember this for the exam, because for the exam you just need to know follow state law. That's what the bar exam is going to test you on. But when you get to practice, you've got to serve the mother, the father, the guardian, or the person having care of the minor, or with whom the minor lives. And then additionally, if the minor is over the age of 16 years, you got to serve the minor too. Or you got to serve the minor also. So let's go back up to the top of this summons form. Where it says notice to, and then the name of the defendant and the address of the defendant. What do you put in that space on your summons if you're serving a 16-year-old minor?
Guardian of,
Yes, ma'am.
I was just thinking minor by code.
Nope.
The name, their name.
You put the minor's name and their address. You put the minor's name and their address, because if they're 16 or older, you got to serve them. And then who else do you got to serve? Their mother, their father, their caretaker, or the person that they live with. So you have to have a second summons for that person. Because if you don't serve both the minor and that other person, what have you got?
Insufficient service.
You've got insufficient service of process because you didn't deliver it to all the right people. Y'all got it? Is that not real simple? Process is defect in the paperwork or who's delivering it, and service of process is making sure it gets in the hands of the right person. And for a minor, you got to serve both if they're 16 or older.
Is that only if the minor's married though?
No.
No, it's not already.
No, if they're over 16, yes ma'am.
So the language says if the minor is married and if the minor is over the age of 16. So what if it's if the minor is married, or like what if they're not over the age?
It says or the spouse.
Oh, okay, okay.
If the minor is married. Don't miss that part.
If they're married, they're not a minor.
Yeah.
They've been emancipated.
Well, if they're 18 and married, technically they're emancipated. If they're 16 or 17 and married, They're not.
I thought when you were married, you were.
Yeah, they still
Spouses
can.
and the minor as well.
Spouses of minor as well, if they're married. Now, the good news in Alabama is this. Alabama used to be a state where you could get married when you were 14. They have now increased that where you can only get married if you're at least 16 with parental consent, but you can always get married at 18 on your own. That having been said, there's no such thing as marriage in Alabama anymore. There's a contract to be together that you file in probate court.
Is there any other state that has that, or just us?
I'm not aware any other state's got that. Ms. Gail.
So just to clarify, if the minor is under 16 years old.
Yeah, y'all don't qualify. Y'all been married. You can't break your contract. Go ahead, Ms. Gale. Sorry about that.
If the minor is under 16 years old and you're serving the father, you put the father's name on the.
You got to put the father's name on here and the father's address, and then you got to put the minor's name on here and the minor's address. So you got to have 2 summonses.
But you have to have, earlier you spoke about the fact that you can have both names, but you have to serve both people.
Yes.
So I'm saying if the minor is under 16.
Under 16, then it's only the parent.
Only the father.
Only the father, the mother, the caretaker, or the person that.
Only that. If they're over both names, then both people serve.
Right.
And this is different from if you have an agent, those kind of things, where you're putting the person who really want to serve, but you still hand it to.
Oh no! Hold on. You're mixing up process and service process. If I'm serving a minor, then how can I get them served? I can serve them personally, or by leaving at their residence with a residence or usual place of abode to a person of suitable age and discretion that lives there, or to an agent. That's how to get it effectively delivered to a person. The fact that a minor and their parent both have to have a summons, or they both have to get their own summons, is different from how you actually drop them off to a house. Can I drop the one off to the father and the minor to the mother if they both live with the mother at the house? Yes.
So this is, the difference is service of the process
Versus process.
versus the process.
Process, I've got to get it to the minor and the parent. Service of process is I can leave it at their residence or give it to each of them personally or deliver it to their agent.
So the process has to do with the paperwork.
The paperwork and that it's filled out properly and it's got the right people's names on it. Yes, ma'am.
So, process is substantive, and the service of process is procedural. The same as insufficient process is substantive, and insufficient service of process is procedural.
You got to get it to the right person. This sort of.
Can you?
I'm trying to break up substantive.
Okay, substantive is it's got the right stuff on it.
Right. Okay.
Now, for you to deliver, if you're going to serve a minor, you're going to have one of these for the parent, and if they're 16 or older, you're going to have one of them for the minor.
I'm just talking about it.
That's the substantive part of it, is that you have to have one of each.
What about they don't get it? Is that fall within the same?
That they don't get what?
Like they weren't served. Is that part of them?
Well, if you don't serve the minor and they're over 16, then that is a procedural defect. If you don't have the paperwork and you don't deliver it, that's 2 problems. You didn't do a summons form and you didn't deliver it to them. So what you do is you raise both objections. Typically, when you're going to say insufficient process, you also throw in insufficient service process. That way you've covered your bases and you've not failed to raise one. Raise them both. So yes, you got to have both the minor and the parent, and then you have to deliver them properly, which means either personally to each one that's named, or leaving it at their residence with a person of suitable age and discretion that lives there, or usual place of abode, or an agent if a 16-year-old's got an agent. Probably not, because if they're 16, they don't have legal authority to sign a power of attorney, right? We clear on minors now? Let's look at incompetence. Federal, an incompetent, it's under G also. A minor and incompetent of judicial district may be served following state law. All right, so state law for an incompetent is actually broken down to two parts, and that's under 3 and 4, C3 and C4. An incompetent not confined, upon an incompetent person not confined by serving the incompetent and that person's guardian. Now, how do you find out if an incompetent has got a guardian?
It's in the probate judge's office.
It's in the probate judge's office. So you look it up to see if they've got a guardian who was appointed by the probate court. Now, that is if they have one, but if no guardian has been appointed by serving the incompetent person and a person with whom the incompetent lives or a person who cares for the incompetent. So let's look at the summons again. If you're going to serve an incompetent that's not confined, how many summonses have you got to have?
2.
You got to have 2. You got to have one for the incompetent, and you got to have another one for the person with whom they either live or the caretaker.
Is that age?
No, just incompetence. Minors are different, but it's the same rule. In federal, it's served according to state law. State law separates minors from incompetence. And then it has incompetents that are either confined or not confined. Right now it's an incompetent not confined. You serve the incompetent and their caretaker or their guardian if they have one. And then for an incompetent who is confined, that's under number 4, and upon an incompetent person not having a guardian and confined in any institution for the mentally ill or mentally deficient by serving the superintendent of the institution or a similar official or person having responsibility for the custody of the incompetent person. So it's just one person you serve. Head of the institution or the person that has responsibility for it. Now, how are you going to know that?
If the about me on their website, or about on the website, just call.
Well, let's take an example. What if you have a car wreck and this person runs into the back of your client's car and it's a terrible accident. Your client's got hundreds of thousands of dollars in medical bills, and the police officer gets the defendant's information out of their billfold. They're unconscious at the scene. You don't know what happens to them, but they get the contact information in their insurance card out of the glove box. You get the police report, so you know that this is the person who's responsible for the damage because this is who the driver was. So you sue them. You name them in the complaint and you sue them. You issue a summons and complaint to that person at that address, right? What if you find out afterwards, oh, this person is got brain damage from the car wreck, hit their head real bad on the steering wheel, that's why they're unconscious. And they're no longer able to care for themselves. What do you have to do as an attorney?
File a summons to the superintendent of wherever they are.
File a summons. If you find out that they've actually been confined somewhere, then you file another summons.
File an alias.
Called an alias summons. You file one to the person in charge of the institution where they're located if they're in one. But if they're not in one, to their caretaker or guardian. Check probate court to see if they've got a guardian. If they don't, whoever takes care of it. But you've got to do that all within 90 days in federal court. So you've got to actually do some work up front to get everybody into court. All right, let's talk about, that's the letter. Rule 5.1 federal. Federal, if you're saying that a statute of the United States is unconstitutional in your complaint, who do you have to serve? How about the attorney for the United States? The Attorney General. If you're going to challenge a United States Code section as being unconstitutional, then you have to serve the United States government's attorney, who happens to be the United States Attorney General. Is that like real obvious? What happens if you're going to sue the state of Alabama? Who do you serve?
Steve Marshall.
The state what?
The state's attorney.
The state attorney general.
Yeah.
Because they are the state's attorney. So let's get back to state rule. Incarcerated persons. You're going to need to know this when you start practicing, so we might as well cover incarcerated persons. Who do you think you serve? The warden?
Well, they get mail.
Yeah, they're legally responsible for them. Here's the thing about prisons. If you ever go to tour a prison, how many of y'all have done that? If y'all toured a prison, first thing you'll hear them say out of their mouths is, a prison is like a city all by itself. They have their own post office. In fact, they've got regulations on how they handle mail. For prisoners, when they get certified mail, it's signed for by the prison's post office, and then they've got delivery inside the prison to get the mail to them. So if you're serving somebody in prison, you send the information to the prison, and the mail service gets it delivered to the person. Specifically, it says, in a penal institution or detention facility within this state, by serving the individual, except when the individual to be served is a minor, by serving any one of the following: the minor, the mother, the guardian, the individual having care of the minor, or the spouse. And y'all, this is the same thing for an incarcerated person as it is for a minor. And also their spouse, if they're over 18, and also by serving the minor personally, incarcerated. So how do you serve somebody that's incarcerated?
Send it to the prison.
Tom?
Send it to the prison.
Yeah, you go on prison visitation day and you take the papers. And then when you go in, you get patted down to make sure that you don't have anything on you that can be considered a weapon. And then the papers that you took in that are all stapled together, they take the staple away from you. Because they think the staple can be used as a weapon. You got to keep your pen. Pens can be used as a weapon. They won't let you keep it.
Can you do certified mail, I guess, like you said?
You do certified mail, and it goes through the prison system for it. I've actually taken that up on an appeal, and they upheld that it was still good service because it went to a prison and went through their mail system.
What role is that for serving in prison?
C5, 4C5. Corporations and other entities. Who do you think you serve for a corporation? Huh? The registered agent that's registered with the Secretary of State. Every corporation's got to have one. You can also serve their officers, managing or general partners for a partnership. What about the state? How do you serve the state?
Attorney General.
Yeah, the Attorney General. But if you're suing like the Department of Transportation, the State Department of Transportation, then you've got to serve the head of that agency as well.
Director.
Now, here's a little note you need to put in. And that is, whenever you're suing the state, you got to watch out for the 11th Amendment. You know what the 11th Amendment says? I've got somebody here who's not even in law school who's answering the question. This is great. Y'all know what the 11th Amendment says? You can't sue the state. You cannot sue the state. You got to get their permission. Now, for a breach of contract, it's real easy. They enter into a contract, they give you implied permission to sue them if they breach it. So they give you that cause of action. But if you want to sue the state of Alabama or any official agency of the state of Alabama, like the Department of Human Resources, they get that case thrown out real fast because you can't sue the state. The 11th Amendment keeps you from doing it in federal court. Now, if you're over in state court, the 11th Amendment still applies, but so does Article 1, Section 14 that says the state shall never be made a defendant.
But there are times where immunity is not granted, where they've breached their immunity and you can't sue them.
Well, there are some times where you can actually sue the state, like if they give you permission. That's one. And then we get into another tricky section, and that is, look at your federal rules. Under I-2 and I-3. This is 4I, 2 and 3. And what this does is it differentiates for you the difference between suing somebody in their official capacity and suing somebody individually. If I'm going to sue somebody that works at the post office in their official capacity as a mail carrier for the post office, who am I actually suing?
The post office.
The post office. Is that an agency of the United States government?
Yes.
Are they immune from suit? Except for wherever you have an exception, like Federal Courts Clean Act or whatever. Generally, they're going to be immune from suit. So you do not usually get to sue somebody in their official capacity. However, if they're working and you sue them in their individual capacity, who are you suing? You're suing them. Can you sue an individual that happens to work for the government?
Yes.
Yes, you can. Yes, ma'am.
Is there exceptions where someone can sue the state after being exonerated for like some wrongful thing?
There are some exceptions. There's federal laws that allow them to get compensation for crimes that eliminates the 11th Amendment argument. The best case I ever found about getting around 11th Amendment immunity is the one case that says if you're suing pursuant to the 14th, 15th, or 16th Amendment, since that amendment is later in time than the 11th, then you can always sue the state for a 14th, 15th, or 16th Amendment violation because the immunity is superseded by the 14th Amendment, which was ratified at a later time. So due process under the 14th Amendment, excessive force claims, a whole bunch of other things. But don't rely on that. Just know that if you're going to sue the government, you're going to have immunity problems, and they don't tell you that in the rule book. That's one of the things you're supposed to learn at law school. Yes, ma'am.
So with this case where the first graders raped another student and the parents are suing the school and the employees?
Which school?
Hoover.
Okay. Hoover City Board of Education is not a state agency. The State Board of Education is. And county boards of education happen to be state agencies. Oh, go ahead.
So Professor Bodie, if, let's say a mail carrier is out delivering mail in his U.S. postal truck and he runs into me. He runs over me and I'm thrown in the hospital. So I could sue him in his individual capacity, but what about respondeat superior? Is that right? Am I saying that right?
Yeah, the 11th Amendment kind of shuts that off.
So that's shut off also?
Right.
Okay.
Now, there's also the Federal Tort Claims Act that you can go under. That's what most people do. So, like I said, wherever Congress says you can sue the government, then you can. But generally speaking, the 11th Amendment says you can't.
Not to get in the weeds, but these school boards or these school systems that get taken over by the State Board of Education, once they get taken over, are they like officially?
You said county schools.
Yeah, but I'm talking about, there's city schools also
that are taken over by the state. Yeah. Then they become under the control of the state agency. All right, look at State Rule 4.1. That's almost identical to Federal Rule 4.1. It says process, and it also goes into other than a summons and a subpoena. You know, there are some of them. We'll cover those next semester when we talked about process of garnishment. Y'all got an idea what that is? Garnish your wages or your bank account. So there's another example of a process. So it's not just summonses which, you know, appear and defend, or subpoena to appear and testify. There's also appear and bring that money that you've got, which is the garnishment. All right, 4.2. If you've got your state rule books out, look at the committee comments to amendment of Rule 4.2 effective August 1st of 2004. And if y'all got your current rule books, it's on page 9. Committee comments effective August 1st of 2004. This is what Rule 4.2D, or 4.2B2, I think, used to look like. And it's sufficient contacts. If y'all don't know this already, 4.2 is the state's long-arm statute. Remember what we started off with in class? Going out, reaching out, putting your hand on their shoulder and bringing them to court. And the long arm extends a little bit longer, includes out of state. Well, in order for you to continue to have jurisdiction over that person, then you have to have sufficient contacts. And what 4.2 used to say is sufficient contacts includes transacting any business in the state. That was number 1. Contracting to supply services or good within the state. How about this? Causing tortious injury or damage by an act or omission in this state, including ownership or operation of a motor vehicle. Does that sound like a case y'all have already read? Guess what? Each and every one of these are Supreme Court cases that you're reading about long-arm statute. Under each of the circumstances where the federal court has said, yes, the state has long-arm jurisdiction over this defendant because of these facts. What Alabama did before 2004 is whenever the Supreme Court would come out with a new case that says, yeah, you can do long arm in this situation, Alabama would modify Rule 4.2 and say, okay, under this situation, you have long arm jurisdiction again. And instead of continuing to amend every time the Supreme Court comes out with another case, what Alabama has done is they've said, let's just pass a rule that says is to the full extent of due process as interpreted by the United States Supreme Court. So they've got long arm to the full extent of federal law. And so anytime the Supreme Court comes out with a new case, Alabama automatically has that because they've adopted a standard that says whenever the Supreme Court says we have it, we have it. Now there are states that don't have that. The smart states are the ones who are adopting a rule similar to this that says to the full extent of federal law. Now, next week, we're going to brief all those cases to tell you when the state actually has long-arm jurisdiction. So far this week, it's getting them into court. You know that you've got to have process. In this case, a summons. That's the original process. To order them to appear and defend, you've got to have the proper information on the process, on the paperwork. You've got to deliver it properly. And then it's got to be, that's process, and then you've got to get it into the hands of the right persons, which is service of process. Now 4.3, state rule, is service by publication.
There's a lot of many cases on that too.
There is. And whether or not the Pacific Christian Monitor happens to be a newspaper of general circulation, I think y'all already know the answer to that. Pacific Christian Monitor? Isn't that Penoyer versus Neff? Okay. First thing you need to know about service by publication, and we'll hit this 3 or 4 times next week, is that you do not acquire personal jurisdiction when you serve them by publication. You just don't get personal jurisdiction. I had no personal jurisdiction. Got it? I had one attorney call me up, it's been a few years ago, that says, hey, I've got this divorce that I filed, and the judge has approved me to go ahead and serve this person by publication. And it's already started to run in the newspaper. But this defendant's going to be here in Alabama on this date. What do I do?
Serve them here in Alabama.
Serve them on an airplane.
Serve them while they're here, and the reason for it is because then the judge has personal jurisdiction to do everything they need to, including determining alimony, property division, everything. But if you wait and just let them be served by publication, the judge doesn't have the authority to do that. So what's your advice to that attorney?
Hit them when they're here.
Hit them when they're here, right?
So what would the judge have authority?
Status determinations, like go ahead and grant a divorce but not divide up property or alimony. They can just go ahead and grant you a divorce, period. So, service by publication. The things you need to know about service by publication. Look at paragraph C, avoidance of service. If you've got a defendant and you're trying to serve them and they're avoiding service, you can file an affidavit with the judge that says, I've tried to serve them. The general rule is you got to try twice. It's not in the rule, but that's generally how many times you try. If you try twice and they're avoiding service, you make that known to the judge in an affidavit asking for permission to serve by publication. The judge will usually grant that. If you don't know where they are and they don't give you any information about where they are, you can go ahead and file an affidavit requesting publication up front, explaining the parties separated 20 years ago. Neither of them's filed for divorce, but this one's finally wanting to move on. So she wants a divorce and has no idea for the past 20 years where spouse is. And a lot of times judges will give permission to publish so that they can go ahead and get a divorce. Yes, ma'am?
In the Madison record, because we get a lot of clients who will want to talk about divorce by publication, you can take out an ad for 5 weeks in the Madison record, but that's like print, which I find is pretty archaic. And you can find somebody on AL.com, but then you have to assume they're on the subscription to AL.com or that they read the news. But it's still something, at least think about.
Yes, ma'am.
If you go the route with the affidavit from the judge, does that bring in personal jurisdiction?
No.
No, so it's still no
Still no personal jurisdiction. All right, so here's the rest of it. Once the judge gives you permission, you get to actually run a publication. And there's a sample publication in Rule 4.3 for a divorce, notice of divorce action. They do them also for termination of parental rights out in family court. Notice to so-and-so who's supposed to be the daddy and any other person who claims to be the daddy. You know, we've got this case going on. If you're interested, show up. If you're not, don't bother. We're going to go ahead and terminate your rights anyway. Now, the idea is the newspaper, the publication has to be in a newspaper of general circulation. General circulation has actually been defined by Alabama Supreme Court as being not necessarily that it goes out to a whole bunch of people, but that it has articles of general interest. So there are these two newspapers in Jefferson County. One's called the Alabama Messenger, and the other one's called the Western Star over in Bessemer. And Alabama Messenger has actually been declared to be a newspaper of general circulation, not because it only goes to attorneys and the library and then some property managers. It doesn't go to the general public unless the general public goes to the library and knows to ask for it. But it's considered general publication because it's got articles of general interest to it. So every once in a while they'll have an article that describes some local upcoming event, and then it's got a recipe in there. Whatever recipe they want to publish. That's enough to have it held as a newspaper of general circulation. So otherwise, it would have been the Birmingham News, but they're not published anywhere, I don't think. It's either in that county where the case is pending, or if there is no newspaper of general circulation in that county, in an adjacent county, and it's got to run once a week for 4 consecutive weeks. The rule is that the official service date is the date of the last publication. And that's where their time begins to run. Now, having said that, federal, remember, allows any other service which is available under state law. You could convince a federal judge to allow service by publication, and you've got to put in there you've got 28 days to answer from the day this last runs. And you can get your publication that way, your service that way, but it's still not going to be in persona. It's only going to be in rem. And if you've read Pennoyer, you know the difference between the two. All right, the affidavit is necessary. How it's published is once a week for 4 consecutive weeks. and then the contents of the publication. And then there's one more in here, certified mail. Flip back over to I-2, which is certified mail. There's one more hidden provision in here that you're going to love. And that is when you attempt to serve by certified mail, if it comes back that the mail was refused, not that it was not deliverable, if it comes back and says refused. Now, if you want to know what refused means, there are postal regulations out there. Go to the Code of Federal Regulations and look up certified mail, and it's going to pull up all the sections for the post office for certified mail. And then there's another regulation that says when they can actually write refused on the envelope. That's when you go knock on the postman knocks on their door, rings the doorbell, they open the door, postman says, I have certified mail for you. They say, no, I'm not taking it. That is refused. If they don't answer the door, that's not refused. If they leave a note on the door that says, come by the post office and pick this up, and they don't within 14 days, that's not refused either. That's unclaimed. It's got to be refused. You get that letter back that says refused, you can file a motion like you do for publication, a motion for permission to serve by regular first-class mail. And you let the judge know that it's been refused. Under the state rule, you can serve by first-class mail. Now that's an exception to an exception. There's not a federal rule on it. The federal rule says you can use state methods. That's a state method, and it's an exception to it. The exception to certified mail. All right, any questions about process and service of process? Is there anybody in here who doesn't have a good understanding of you got to have the right papers delivered by the right persons, and then you've got to deliver them to the correct persons. Delivering to the correct persons is service of process. The right papers and delivering it the right way is process. And then if they screw up one way or the other, it's either insufficient process or it's insufficient service process. Okay, if you came in after I called roll, please come up and see me so I can get you on the roll. Next week is going to be briefing cases week. Be prepared to be called on if I don't have volunteers.
Well, Pastor Bodie?
Yes.
For returning the witness on the next...
Process and service process. Summarizing.
Okay, that's all.
How do we know
That's it.
what our reading is? You going to tell us what pages?
It's on the twin site.
Okay.